All right, good afternoon, everyone. On behalf of the Federalist Society Board and society at large, welcome to our first in-person event since, I believe, fall of 2019. So this is very exciting for all of us. We're very excited to jump into a discussion of the issues facing the Supreme Court this term. There's a lot of significant cases coming up, so we thought we'd launch the semester with a term preview with two leading constitutional law scholars and court watchers. But before that, some housekeeping items. If you haven't, help yourself to food. It's back there, it's for you, and there's plenty. If you have not signed in, there should be 2 sheets with QR codes circulating. Please take advantage of those. They're very helpful for us. They help us stay in contact with you. Finally, if you're free, join us this Friday night. We'll be at the Owl's Nest Brewing Company in Austin for a social event. Jumping onto the sign-up sheet is a great way to be informed of things like that. And also heads up for Wednesday, October 6th, we'll be having a talk with Ashkan Kazarian, a content policy manager at Facebook, about Section 230, the First Amendment, constitutional values, and content moderation. Now, before we jump in, I'd like to introduce our speakers. The first is Professor Josh Blackman of the South Texas College of Law at Houston and adjunct scholar at the Cato Institute. He has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. He has written more than 6 law review articles that have been cited nearly 1,000 times. He was elected by Forbes magazine for the 30 Under 30 in Law and Policy. Josh is the president of the Harlan Institute, founder of Fantasy SCOTUS, and the internet's premier court fantasy league. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and BBC. He is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and other leading national publications. Joining him will be our own Professor Greenfield, an internationally recognized scholar of constitutional law and corporate governance. Professor Greenfield is a professor of law and Dean's Distinguished Scholar here at Boston College Law School. He's the author of 3 books, including Corporations Are People Too, and They Should Act Like It for the Yale University Press.
I like that title.
He is also the principal author of the 2 Supreme Court volumes of Moore's Federal Practice, a frequent public commentator on broadcast and cable news programs, having appeared on CNN, MSNBC, NPR, BBC, Al Jazeera, and Fox. His essays have appeared in the New York Times, the Washington Post, Atlantic, Slate, SCOTUS Blog, the Boston Globe, the American Prospect, Salon, and The Nation. He has also published numerous scholarly articles in leading legal journals, including the Yale Law Journal and Virginia Law Review. So without any further ado, let's welcome our speakers and commence our discussion.
Thank you. Thank you so much. I'm a visitor, so I think I have to keep this thing on up here. Right? Yeah, I think so. It is such a treat to see people in person, right? In another world, I used to travel to see 50 law schools a year, and that stopped overnight, where it was 0 in a year and a half. So now I'm back here, and I'm very honored to speak to you all today. Professor Greenfield is an old friend. We'll be talking today about the Supreme Court term. So let's start with some numbers. The first number is 6. For the first time in any of our lifetimes, there are 6 conservatives on the Supreme Court. To get this sort of level, we have to go back, the New Deal, Kent? I mean, we have to go back maybe 80, 90 years to get to this solid of conservative bend. Do we have a 6-3 reliable conservative court? No, not even close. This past term witnessed a lot of cases that went not exactly how conservatives expected them to go. And in my view, 6-3 is not a helpful number. The better number is 3. I see the court as a 3, 3, and 3 split. So you have 3 camps. You have the court's 3 progressives, Justices Breyer, Kagan, and Sotomayor. They, for all intents and purposes, vote as a block. They break up every now and then, but they're usually hanging pretty tight. But they're only 3. In order for them to make a majority, they have to pick off 2 other votes. And the most likely candidates are Chief Justice Roberts, who for some time was a swing vote, Justice Brett Kavanaugh, who perhaps unexpectedly swings to the left every now and then, and much to the surprise of many people, not me, is Justice Amy Coney Barrett, who indeed has had a few majorities with the court's liberal members. So in any given case, the court's 3 liberal members may drag in 2 conservative members, which forms a 5-member block. Doesn't happen always, but it happens often enough. There were more 5-4 decisions with the court's liberals in the majority than otherwise. Then you have the other camp, the 3-3-3, the final 3, is the court's most conservative members. You have Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch. And even Gorsuch isn't always in that camp. But these are the 3 most conservative members. So in any given case, even with a conservative victory, you can see 3 conservative members and 3 more moderate conservative members splitting in half. For that reason, last term was not this sort of superstar victory that conservatives perhaps expected, but it definitely shifted things to the right. Justice Ginsburg passed away about 1 year ago today. The court looks very different now than it did prior to her passing. So September 18th, so right around a year ago. Let's give some statistics to get started. Last term, there were 55 signed opinions. 55. That is the second lowest number since the Civil War. The lowest was actually the prior year, the COVID term in 2019. So the court isn't actually deciding many cases at all, but they are deciding many more cases without the benefit of argument. These are the so-called shadow docket orders. You heard the expression shadow docket? Didn't exist when I was in law school, when Kent was in law school, but now it's everything you have to know. The so-called shadow docket is when the court decides a case on an emergency basis. There's no argument. There is a very compressed briefing schedule, and they'll often issue like a 1-page or even a 1-sentence order saying, lower court, you're put on hold, or lower court, you're agreed, right? These decisions have come under a lot of criticism. People say the court should not be deciding important cases on this sort of super expedited basis. I think there's some merit there. But for a lot of the cases involving COVID, there wasn't much of a choice. These were urgent appeals, and they had to resolve somewhat expeditiously. But there are other cases involving eviction moratoriums that they're sort of also rushing through. Keep an eye on this shadow docket. Now, some other statistics for your information. Of the 55 opinions last year, what percentage were unanimous? About half. About 47%, so 26 out of 55. About half of the cases last year were 9-0. Not what you expected. What about the cases that were 8-1 with just a single dissenter, right? 60%. So in 60% of the cases, there was either 1 or 0 dissenting votes. So there's a lot more agreement on this court than you might think if you just sort of read the headlines. There were 12 opinions that split 6-3. There were only 6 5-4 cases. So out of all the cases last year, there were about 55 cases, 6 split 5-4. 3 of them were in the liberal direction. 2 were in conservative direction, and 1 was sort of weird, mushy, right? So even with a solid 6-3 court, there are not all these 5-4 decisions or 6-3 decisions going to the right. In fact, they're actually quite divided. Okay. Chief Justice Roberts also issued his first solo dissent in a case involving a mootness, which is not exactly a sexy topic, but Roberts seemed really riled up about it. Justice Kavanaugh is the man in the middle. He was in the majority 97% of the time. 97%. That is the highest level of any justice since one man named Anthony Kennedy had it some years ago. So in many regards, Kavanaugh is the middle justice. I don't think it's fair to call him a swing justice. I think Kent would probably agree with me on that one. I think Kavanaugh is far more conservative than Kennedy ever was, but Kavanaugh is not a doctrinaire. He's not fixed in the same way that Clarence Thomas might be. Next up is Justice Roberts. Roberts was in the majority. Where is it? I just lost my note. Sorry, 1 second. Roberts was the majority 91% of the time. Barrett was the majority 91% of the time. Gorsuch 90% of the time. All the way at the bottom was poor Justice Sotomayor, who is the majority 69% of the time. She is the furthest to the left, and therefore she's in the majority the least. Roberts and Kavanaugh, the justices most likely to agree. They agreed, I think, 94% of the time. The least compatible match was Sotomayor and Thomas. They agreed 53% of the time. So they're basically never in agreement, maybe more than half. All right. So these are some of the numbers from last term. I think what these numbers convey is we don't have the sort of juggernaut, this right-wing court in every case. But this term might be a little bit different, as Ken is gently nodding over there in the wings. Let me just walk through some of the big cases from last term before we get to this term. There were many cases that involved President Trump that simply vanished after he left office. So the low number, the 55 number case, was even lower than usual because a lot of the cases just fell off the docket. So one was called Wolf, the Innovation Lab, which involves the Remain in Mexico policy, which is being litigated now, you might have seen. That case went away. Trump versus New York, this was the census case. Can they put a citizenship question in the census? That case just went away. Trump v. Sierra Club, that involved the border wall, it went away, right? It's sensing a pattern. Another case involving funding for various types of clinics went away. So a lot of the bigger cases just sort of vanished. What else was happening last term? The Obamacare case, the court turned that away by a 7-2 vote. I've written more books about this than I can even count, but I'll write another one now. A big case involving adoption, Fulton v. Philadelphia. A Catholic charity group in Philadelphia would not work with gay couples for adoption purposes. They also wouldn't work with unmarried couples in general. They won 9-0. Not what you'd expect. All 9 justices agreed that the Catholic charity should prevail. It was also a very narrow decision. The court stopped short of overruling some old precedents that were unpopular in some quarters. But again, it was a 9-0 case. We have free speech. This was a solid 6-3 conservative majority. Americans for Prosperity versus Bonta. California required nonprofits to disclose to the state their donors. The court held that this was a violation of freedom of association, that you can't be required to give up your donors. This one went 6-3. Okay. Another case involving the Mean Girls, the cheerleaders, Mahanoy School District versus BL. There was a girl who did not make the JV, the varsity cheerleading team, so she put up a Snapchat where she said the F word and lifted up her middle fingers. She was disciplined. Again, the court split here 8-1, saying the state could not punish her. Justice Breyer wrote the opinion. Case was a bit incoherent. Don't really know what the test is, but the student prevailed. Justice Thomas was a lone dissenter. He thinks students have 0 rights at all. None. None. I'm not exaggerating. He thinks when a student is in school, the parents are gone, and the teacher's in loco parentis, you have no rights. If you want to be strip searched, good. If you want to have your rights violated, good. You got nothing. So that's Justice Thomas. He's been very consistent on that point for the last 20-something years. He might say it's in loco, but it's in loco parentis, as they say. We had a number of cases involving the separation of powers. Collins versus Yellen was a removal power case. Can the single director of the Federal Housing Finance Agency, the FHFA, be given protections? Court says no, he must be removable at will of the president. Okay, that was a 9-0 case. Again, not what you expect. 9-0 case. Another case called Arthrex involves protection for patent judges. Oops, sorry about that. And the court also said that these patent judges can't be given protections from removal. What they did after that's kind of messy. Election law. Here was another 6-3 solid right majority. This was called Brnovich. Arizona enacted some policies that restricted voting. For example, if you voted not in your precinct, your vote wouldn't count. There was limitations who can handle an absentee. Court said those are fine under the Voting Rights Act. Justice Kagan wrote a very, very vigorous dissent. I think that's a good way to describe it. Let's see what else we got. We have some. There was a woman who was getting into her car. The cops thought she was someone else, and they told her to stop. The cops didn't announce themselves as cops. The woman thought she was getting carjacked, so she got into her car. Then the cops shot her in the back several times. Get this, she was paralyzed in her arm, yet she somehow drove 80 miles to a hospital. Superwoman, right? So the question is, was she seized? Even though she was shot in the back and had a paralyzed arm, she managed to keep going to the hospital. And by a 5-4 court, the Chief Justice, I'm sorry, 5-3, the court said, yes, she was seized within the meaning of the Fourth Amendment. The dissent said she was not seized because she was not stopped. She kept going. This was actually a very hard case. I think this was the toughest cases of the year. It didn't get enough press, but this was actually a very difficult case where Roberts and Gorsuch were on opposite ends of the universe. Okay, what else we got? Oh, any of you guys taking property this year? Probably, yeah. You'll study a case in property called Cedar Point. This involves labor organizing. California had a law that said if you were a union organizer, you were allowed to go into a farm for, I think it was 3 hours a day for 120 days a year. The farmer said, no way, that's a taking, right? You can't force me to let this guy into my land. And the court agreed, 6-3. This was probably the most biggest conservative majority of the year. I'm a property professor. This case was huge. Roberts really made a strong protection of property rights in this case that people didn't see coming. All right, next term, I'm almost done, Kent. We'll get to you in a few minutes, okay? Next term, we got big stuff. Big stuff. First off, guns. New York State Rifle and Pistol Association versus Bruin. You maybe learned in con law about the Heller case from 2008. Heller said that the Second Amendment protects an individual right to keep and bear arms. And a couple years later, then McDonald, which says that this right also limits state governments. But since Heller and McDonald, when I was in law school, I was a 3-0 when Heller was decided. Since Heller and McDonald, we've had nothing. The court has refused to take any Second Amendment cases. They've just said, we don't want to do it. But now, the numbers are different. Kennedy's gone and Roberts is not in charge anymore. So I think Justice Barrett and perhaps Justice Kavanaugh provide the necessary votes to grant certiorari, you need 4 to grant cert. And I think there might be the 4th and 5th vote to rule in favor of the Second Amendment. But I am not holding my breath. This case is difficult for a lot of reasons. And I think, I am a Second Amendment advocate. I litigate these cases. I still don't think we're going to win. I presume we're going to lose, but the justices may be very leery about deciding a gun case and telling states they can't protect people's safety. And I can see the court saying we go the same way in both cases. We let the states regulate abortion and regulate guns. But if they split it, right? You can't regulate guns, but you can regulate abortion. They may not want that. So it's possible they split the difference or not. I don't know. Okay, so the big case of the term, maybe even biggest case of the decade, I don't know if I'm exaggerating, it's called Dobbs versus Jackson Women's Health Clinic. This was a clinic in Mississippi. Mississippi enacted a law that prohibited abortion at the 15-week mark, which is before viability. Under any standard of technology, 15 weeks is before viability. You've probably studied in common law Roe and then Casey, right? Roe had these sort of trimester frameworks. That was gone. Now we have Casey, which says we have a line at viability. After the point of viability, the state has a lot of latitude to prohibit abortions. Prior to the point of viability, it's much harder. Right? It's much harder. Mississippi deliberately enacted a law that prohibited abortions prior to the point of viability, right? It's basically a test case law. They enacted this hoping to trigger some sort of Supreme Court decision that went against Roe and went against Casey. This case will be argued on December 1st. It's already on the calendar. It's going to get ugly. Doesn't matter what you think about abortion. Doesn't matter what you think about the court. There's going to be a lot of vitriol thrown on both sides of this case. Lurking in the background, of course, is this Supreme Court commission. Are you on it, Ken? No, okay, good. Is this President Biden appointed as, I don't know. There's like 35 people. I just assume everyone's on it. Except for us. No, they would not invite me. No. There's a Supreme Court commission from President Biden that's looking at court reform. Court reform. How do you reform a court with 9 members? Well, maybe one way is to have more than 9. So lurking in the background of this abortion case is a very strong movement to reform the court, or what we may call expand or pack, or whatever else you want to say. And I think there'll be a very strong movement to try to put pressure on the court to not nullify Roe as a way to preserve the 9-member court. The Chief Justice, of course, cares very much about these things, but he's only one vote. Again, 3 + 1 is 4. You need 5. There'll be pressure on Justice Kavanaugh. You may have seen people were protesting at his house. This is bad. They went to his house and were protesting outside of it. They were chalking his sidewalk. I think these things are actually foolish. They'll backfire if anything else. If you're protesting at my house, I'm like, screw you guys. But there's going to be pressure. I'm sure they'll go to Justice Barrett's house. She has young children. You know, she's a mom. You know, she has young kids. But this term's going to get ugly. In the abortion case, maybe there'll be arguments that even if Roe was wrong, in case it was wrong, we stand by for stare decisis, the standby precedent. I don't know if the court can go that far. The conservatives in the court do not like substantive due process, this idea that the due process clause protects right. If you read the Chief's dissent in Obergefell, the marriage case, he does not like this doctrine. Maybe the court says, well, we overrule Roe, but we create some new standard that's perhaps more permissive for the states. Even then, though, you have to accept the basis of substantive due process. Now, you probably all read in high school Moby Dick. Remember that book, right? Captain Ahab chased the white whale for his entire life. In my mind, John Roberts is Captain Ahab and Roe is Moby Dick. I think he'll go to the end of the earth to stop it. I think he's had this sort of mission for 40 years. But then again, if you read Moby Dick and not just the Cliff Notes, you know that, didn't turn out too well for Captain Ahab. He died at the end of the book by the whale. The whale killed him. So I don't know what that says, but I think, yeah, I don't know. But I think this is a case where Roberts is ready to go. He says, okay, Obamacare, whatever, voting rights, whatever, but this is the way out. We have more cases. Carson versus Macon, which is a case I think Kent might want to mention, 8 to 10 religious schools. I think this one is going to be a reversal for the First Circuit. The court was very strong in a case called Espinoza that you can't deny tax credits for use in religious schools. The First Circuit drew a distinction of why the main program was different. I don't think it's going to hold. We have affirmative action with a school right here in town on the other side of the Charles River. We got Cambridge, we got Harvard. Harvard has a affirmative action policy, and according to the allegations, it discriminates against Asian kids. You can read the numbers. I won't argue them here, but the standards for Asian students are much higher than for other students. Now you might say, wait a minute, Josh, Harvard's a private school. Why is it even subject to the 14th Amendment? These are not 14th Amendment cases exactly. They're based on federal law, and federal law says if you accept funding from the feds, you cannot discriminate on the basis of race. So this isn't even the 14th Amendment enacted 150 years ago. It's a federal statute enacted in the 1960s. Okay? The court may decide this case this year, or it may go to next year. I do not know. A lot depends on whether they want to hear it with abortion. So you might actually have in one term 3 of the most hot button issues: guns, abortion, and race affirmative action, all in one term. This is going to be like the Royal Rumble. There's so much going on. But wait, there's more. I'm from Texas. I come bearing gifts. The Texas abortion case will very likely be back at the court this term. You may have heard the United States sued Texas, and actually they didn't just sue Texas, they sued every person in Texas. So I'm actually a defendant in this case. I'm perhaps fleeing the jurisdiction, I don't know. But Texas, the United States sued basically every man, woman, and child in Texas who can bring a lawsuit challenging this abortion providers. That case may make it to the court this year. I'm not done. President Biden has a new vaccine mandate. It's not operating on individuals, it operates on employers. If you have 100 employees and you don't require vaccines, the employer will be fined. This is going to trigger litigation in basically all 50 states. And this is actually crazy. This rule is based on OSHA, the Occupational Safety and Health Act. OSHA has this weird rule that if everyone sues in different courts, they're consolidated to a single court. So no circuit splits. How are they consolidated? You ready for this? There's a lottery. I'm not joking. A clerk actually draws a number out of a drum. I swear, I'm not joking for you. So you're going to have all these cases consolidated in a single circuit. And as soon as that court rules, it goes right upstairs to the Supreme Court. So the court may, on top of everything else, do abortion in Texas, and may do the vaccine mandate from the U.S. government, the OSHA rule. There's more. Usually a term we say, oh, it's kind of boring or excited. This is probably the biggest term since I've been following the court. I don't know, Ken, if you agree or not, but there's just so many things. One way or another, by June of next year, by June of 22 or July of 22, we'll know where the Robert court stands. Either they will not, right? They've either restricted affirmative action or not. They said the vaccine mandate's okay or not, right? This is like the Show Me Sunday version, right? They're going to show what they're made of, or is it Show Me Saturday? They're going to show what they're made of this term. We'll know a lot. And I'll probably be back here next year complaining whatever they did. All right. Thank you all so much. It's a pleasure to be here, BC, and hope to hear comments from my friend Kent. And I'm happy to take your questions afterwards. Thank you.
So interesting, Josh. It's always good to hear you, and I feel like, do you mind if I shut this so I don't end up?
If you
Right.
close it, the camera will turn off.
Okay, all
lower
right.
it.
No, that's fine.
Okay. Is that good?
Yes, good. It's always a pleasure to be with you and talk. I think we disagree a bunch, we agree a bunch, but I think our disagreements are always fun and illuminating. Let me say a few things just about the court and where we find ourselves and how things have switched somewhat at the court, and then I'll highlight a few things that I'm particularly watching for this year. I mean, I think one of the things that Josh mentioned that has changed, that's different about the court now than we've seen, is the use of the shadow docket. You know, you've seen the court, especially over the last 18 months or so. Part of this was mandated or required in a sense by COVID, but you have a lot more substantive issues being dealt with by the court on the shadow docket. When I clerked there, which is now ancient history, the shadow docket was mostly an occasional stay or an injunction to effectuate the working of the court, and then the capital cases, the death cases that would come up in the middle of the night. But now, you know, we've seen the court really weigh in on substantive matters of religious freedom, the eviction ban, immigration, the abortion ruling about Texas, and in addition to the regular docket of death, regular shadow docket of death cases. Another thing I think that has shifted over time is the notion of court, sort of how well they're getting along within the court. My sense, Josh, and I'm eager to hear your views on this, is that there's a lot of vitriol inside the four walls that didn't exist before. You know, I sort of use as a reference point my old boss, David Souter, who sat next to Antonin Scalia his entire career. And you know, they stood in opposition substantively in a lot of ways, but you could see them bantering back and forth on the bench and nudging each other and sharing a joke. And I know that they were quite friendly with each other off the court. And even someone that like Clarence Thomas, who again was very different from my boss substantively, I think there was a lot of affection between those two. Still is between those two. I know Justice Thomas celebrated his 30th anniversary on the court recently, and I know my boss sent him a letter to be read by his clerks at the celebration. And I think my boss would always speak very highly of Justice Thomas's family and his dedication to his family. Although based on his jurisprudence, I'm not so sure I'd want a vague memory of that. Interesting. So, but I think there's Neil Gorsuch's first day on the court. I remember him raising an issue about, well, you know, he waited to the end of an argument and he says, "Can I please ask a question about the text, which I think we're supposed to be talking about?" And then, like, quickly thereafter, Justice Kagan sort of asked a pointed question to sort of reorient the conversation and sarcastically sort of slapping Neil Gorsuch down. And my sense is, I think watch for this year, Josh, is that it's unclear whether Roberts is in charge, right? Like, for sort of setting the agenda and sort of deciding a lot of these 5-4 cases around. Now Roberts sort of ideologically is more to, I mean, I think he's ideologically closer to the right. Center has the juice in terms of his interpersonal relationship. So, you know, I think the person with the juice in terms of the institutional power is probably Sam Alito. I mean, I think he's a real intellect. He's deeply conservative, but not an idiot. But, you know, Alito lost a lot of cases last year. So last year, it makes it seem like it's not Alito's court, but maybe this year things will change. I think the other thing to notice is, and this goes to the court reform issue. I think one of the things that has definitely changed over the last few years, and now that we have a 6-3 conservative court, is how the Overton window has switched, right? The Overton window is are about what's unanimous, what's not, 5-4, what's not. In some ways, it's not that surprising because regardless of who's on the court, there will always be 5-4 cases because the agenda is set by that the ideological shift has occurred, and the 5-4 cases are really around matters that are much further to the right. Talked about. This is a case where this is something that a couple decades ago would have been so far-fetched to even think about. The court would have endorsed something that is so contrary to sort of longstanding thought about a wall to free speech. That the things that they are being considered now is shifting, has shifted speech front. The abortion as well, voting right. Adam Cohen, Supreme. The court was in the late '60s was one vote away from as a due process freedom, and really establishing with teeth the voting as a protected liberty. But those things are not in the conversation at all anymore. And I question about court reform is a good one in the sense that do we think that the that the Democrats have the backbone to impose new structural changes on the court, given the fact that they're probably looking at a generation or so of a strongly conservative court? Any taste for court reform as drastically conservative as some people might expect? Because if you'll remember, next year is midterm elections. If the court ends up striking down the right to terminate a pregnancy, ends up striking down affirmative action, ends up striking down vaccine mandates, ends up upholding the right to bear arms outside of one's own home, which is the issue in the New York gun case, then I think there'll be quite a taste, quite an appetite, and quite a lot of political pressure on the ideological left in this country to make changes in the court. And in fact, usually midterm elections sort of revert to the norm. And if last year you had a slight adjustment to the left, the Democrats won the Senate, held on to the House, got the White House. Normally, you would expect the midterm elections to shift back, and now with the redistricting, my guess is that in a normal. But if the court really turns hard to the right, whether Roberts can sort of maintain this court. I think Roberts is known for being quite sort of sophisticated. Imagine a 3-3 outcome, not unlike, but what you could imagine is a sort of a middle ground cobbled together stare decisis kind of decision. Of course, Casey was only less than 20 years after Roe, and it's now been 30 years again since Casey. So the stare decisis arguments, if anything, have gotten stronger. Just noting, I think Josh is right. The case from Maine is going to be a big deal. The gun rights case is a huge deal on behalf of the clinics in Dobbs. She argued June Medical Services a couple years ago, and that was her first oral argument at the Supreme Court, and she was amazing. So I'm like, if chance. By the way, I counted this morning how many amicus briefs there are in Dobbs. Did you count yet?
I counted on the Dobbs side.
I did. Is that right?
Not a single big law firm filed a brief against Roe.
I thought that the most interesting amicus brief in that case was John Mitchell's, which for Texas Right to Life. John Mitchell was this Federalist Society attorney that crafted the Texas law that's been an issue lately, and he writes in that case that Roe is on is essentially built on sinking sand, constitutional sinking sand. And if we overturn Roe, or the court overturns Roe, they ought to go ahead and overturn Lawrence and Obergefell, and even Loving he retreats to a statutory defense of Loving rather than a constitutional defense. So I thought that was interesting. Another couple of cases, one with a local tie, the Dzhokhar Sarnev's appeal is going to be heard this term. You know, Sarnev is one of the two bombers in the Marathon bombing case. He's in federal prison. He was tried, convicted, sentenced to death by a Massachusetts federal district court. The First Circuit overturned the execution, the capital punishment, because of difficulties in voir dire and some evidentiary concerns. So that case is going up to the Supreme Court, and sort of in a weird juxtaposition, the Biden administration is going to be arguing in favor of capital punishment in that case. The other case where the Biden administration is sort of in a weird spot is another First Circuit case, and it's the United States versus Valle Madero, which is a case from Puerto Rico, where under the Social Security statute, citizens of the United States who live in Puerto Rico cannot receive Social Security benefits, and there's an equal protection challenge to that. And the Biden administration is going to be defending the statute against the claim by the I said Social Security, I mean supplemental security income states. So I think that's another interesting case to watch. Of course, there's also the death case, the prison death case coming out of Texas, where Texas can prohibit a person's minister from being in the death chamber and be audibly praying for the prisoner during at the moment of death. But those are some things that I'm watching for in both sort of headline cases and lower tier cases. But Josh, I'm happy to open it up for questions and yeah.
Okay, thank you so much. That was fantastic. Let me resume just one point Kent mentioned about the personal relations in the court. I worry about that as well, and I wonder how much they are getting along. Perhaps what exacerbated that is they haven't seen each other in person in a year and a half, right? I mean, you probably know this. It's hard to keep a friendship when you're just looking at a little Zoom screen. And the justices have just been out of town. They've not actually even, Justice Breyer is here, he's in Boston. He's not actually in DC. Justice Barrett, except for a couple public events, she hasn't seen her colleagues in person, which is crazy to think about. So I think when the justices are back in person, that will help to calm down the pressures. But personality-wise, Justice Gorsuch is YOLO. He doesn't care. He's going to do his own thing. I think Justice Barrett may be a little more politic, but there's definitely different dynamics. Souter, for whatever he was a gentleman. He was gracious to all, and the Trump appointees perhaps are not that gracious. All right, we have some time left. Maybe we can take some questions from the students. Happy to hear what you guys have to think. Yes, at the back.
You spoke about a lot of potentially very momentous conservative decisions, and then wanting to balance that so that it's not, I guess, too much at once.
Mm-hmm.
Is there a potential for horse trading in between the justices in that case?
I'm sorry, in which case? I think that's the first part of your question.
So
Horse trading across the various cases.
Oh, across so you give me abortion, I'll give you guns like that? Oh, God. Yeah, so I want to say the answer is no, but I think the answer is probably yes. I think specifically the combination of guns and abortion makes the horse trading very possible. Because I think I mentioned this earlier. You can imagine a term that says, okay, Texas, you can go ban abortion. New York can go ban guns. Consistent, right? And that will at least have the veneer of some sort of consistency. Whether you agree or not, it doesn't matter. That's something I think the Chief Justice would want to do. I think he horse traded in the Obamacare case. I wrote an entire book about it. I think he said, okay, we'll modify the Medicaid expansion. We'll say you can't have a commerce power being a taxing power, sort of just mixed and matched. But Roberts ain't in charge. He needs Kavanaugh and Barrett to go along. And Barrett may believe that Heller goes outside the home. And Barrett may believe that Roe was completely wrongly decided. And for a justice to start horse trading signals to their colleagues that they're going to be motivated by factors that are not the law. And it's hard to break that thing. I think the Chief Justice's decision in the Obamacare case set a understanding of him that's pervaded to this day. I don't know if Barrett and Kavanaugh will do that. I don't. Kent, what do you think?
I don't think there's horse trading per se in the way that people negotiate contracts, or that you might have seen horse trading other ways. Having said that, I think a justice take on one case will to influence another justice. So you have to be mindful of that. So, for example, I think Josh is probably. It's interesting to think about whether the view on the New York gun case would affect Dobbs. The gun case is argued in November. Dobbs is a month later. They will have already voted on the gun case before they even hear Dobbs. But if the gun case is written in a way where it's you strike down state regulations, it's just going to be hard for a justice to pivot without a lot of explanation. And so I think, it's interesting that you think that Roberts horse traded in the Obamacare case. I don't know if horse trading, I agree with you that I think he was, I would say splitting, to mix metaphor, he split the baby.
Poor choice of words, Ken. Don't throw the baby out with the bathwater here. That's even worse.
He didn't horse trade, he split the difference.
Fair point. I think there's a question over here. Yes.
I was just going to ask, to the extent that the Madero case kind of harkens back and raises the insular case precedent, it's really kind of rather cool, and that Judge Elby has been sort of on a mission about. To what extent do you think that they will look back at that in the nature of that case?
I think that was yours. Do you want to talk about the insular?
Are you talking about the Puerto Rico case?
Yeah.
Yeah, I don't know all that case history, so I don't know how to evaluate it. I guess what struck me as interesting was because just almost from a political or procedural perspective, is like how otherwise wouldn't be so eager to do. And I think that is almost a requirement of the office. Because the SG is there representing the president. So that was what struck me as interesting about that case. But I don't know the substance of it.
So the insular cases, right? So the insular, this may surprise you, but to this day, if you are born in Puerto Rico, you are not a citizen by virtue of the Constitution. To this day, you're a citizen by virtue of statute. And in theory, Congress could repeal that statute. The reason why is a number of cases from the late 1800s called the insular cases, which said that the U.S. Constitution does not extend to the various territories. And if you read these opinions, they say these people are inferior, they're not part of our nation, they don't deserve the Constitution. It's very nationalistic. If you just read the cases, they're there. There has been a century-long campaign to overrule the insular cases. There are a number of cases from Guam and American Samoa where people who were born there try to assert that they're citizens by birth and not by virtue of statutory authority. In their cases that they go to the military, they're trying to seek passports. They've mounted every single test case. And the Obama administration, the Trump administration, the Biden administration all agree that the insular cases should remain. And this puts them at odds with a lot of people from Pacific Islander communities and elsewhere who think this is insane. So to answer your question, which is a good question, I don't think there's even 2 votes to rule the insular cases, maybe 1. Justice Sotomayor had an opinion in the Puerto Rico bankruptcy case from 2 terms ago. I don't know enough about the topic, but she gave a history that I hadn't followed. There's actually some argument that Puerto Rico is effectively an independent nation already. We just didn't know it, right? There were some treaties and agreements with the UN in the 60s that it's actually its own nation. So it's a divisive issue. Even in Puerto Rico, they have these various plebiscites, these various referendums, and the people are pretty split over whether to become a state, because to become a state is to deny you're actually your own sovereign. So you actually lose some autonomy to become a state. So this is a very thorny issue in which the Biden administration has just said, we're going to keep things the status quo. We're not going to disturb it. But it's an issue that I perhaps need to learn more about, but it's a very complicated issue. Yes, right here.
So this might be too much hypothetical. So imagine that, it's a conservative or a report as expected to be with all these hot button issues. And then at the end of the term, you see Justice Alito and or Justice.
Retire under a Biden presidency?
Yes.
Oh, no chance in hell. They're going to have to wheel Clarence out. He's not retiring now. I mean, yeah.
So what would your, I think there are people who might think that they've been waiting around for cases like this.
Yeah.
This is exactly why they stay on the court for as long as they have, maybe. But what would you think that the legitimacy of the court, how would it fare in a scenario like that? Because already people, talk about retirements of Justice Breyer for political reasons, right? You want people to retire at certain strategic moments. And I think it degrades the quality of the legitimacy of the court. In a scenario like that, how do you think?
In other words, they got their white whale, they can now step down. I think it's so unrealistic, but I'll be happy to just entertain the hypothetical, which is a fun one. Retirement, right? Most people don't choose when they step down because most people eventually are either pushed out or they die or whatever, right? People don't stay in their jobs forever, except maybe tenured law professors. The justices are unique in that no one can make them retire. And in the last 20 years, we've had 3 people die in office. We had Rehnquist die in office. We had Justice Scalia die in office. We had Justice Ginsburg die in office. So we realize you're going to be there until you die, or you can step down early. So now, when do you step down? Justice O'Connor stepped down not for political reasons, but for personal reasons. Her husband had been falling into dementia, and she wanted to take care of him. That's those benevolent retirement in Supreme Court history, right? Justice Souter stepped down as quickly as he could when there was a Democrat in the White House. I'm not speaking after him, but the Democrat in the White House, he stepped down right away. Justice Stevens sensed that he was having some health issues, which apparently he wasn't. He was quite cogent for many years after, but he stepped down right after that. I've never heard of a justice stepping down because they've achieved everything they want to achieve, because there's always more to achieve, right? Roe is not the only white whale. There are other whales in the ocean. But I do think if, imagine Alito said, all right, we're calling it quits, that would signal that he's doing his job for the purpose of getting that white whale. Once he got it, he didn't need the job anymore. So I think I see the purpose of your question.
I think the question that's been on my mind is why hasn't Breyer resigned? And would he wait till with the leadership? Now that Ginsburg has passed away, and so he loves that leave when he dies. Much like I will leave this job when I die.
Me too.
And the other rationale might be that he's waiting for something to happen, and what he might be eager to wait. He might be looking to take over. And there was a judge in the district court in D.C., Judge
Ketanji, yeah.
Ketanji Brown. Jackson Brown? No,
Brown Jackson.
Brown Jackson, sorry. Thank you, John. And she was just elevated.
It's like KBJ. It's like LBJ, but KBJ. That's how I remember it. Okay.
Not Jackson
You're
Brown, like the artist that I used to work with. And she is on the DC circuit now, so there may be some waiting for her to get some seasoning there. The other wait that possibly could be is that he's waiting to have a sort of this energy after a really bad term, so that the confirmation will be easier. Like if the term is really bad this year from a Democratic perspective, then the confirmation for someone really liberal will be easier in a year than it will be now.
Just read into the shadow docket and kind of the impact or like the effect of the shadow docket on the technically they just didn't
Well understood, right? So Texas has a law called SB 8. The government cannot enforce SB 8, right? There's no role for the government to enforce that law. Only private parties can enforce it. So the abortion clinics decided to sue a single judge in East Texas and a private citizen in East Texas. Those are the only relevant defendants. The other defendants didn't really matter. As the case came to the Supreme Court, there's only one defendant, this one judge. Even if the court gave Planned Parenthood all the relief they sought, it would have made no difference because every other judge in Texas could have heard the case. There was no certified class because of the nature of how this litigation proceeded. There was no way for the court to actually give Planned Parenthood the relief it wanted. It couldn't with the case. The court can't say, you know what, party A is here, but we're going to give relief to all 100 parties in the state. Unless the court had basically vacated the district court decision and ordered the district court to certify a class, and issue an injunction against the class, there's nothing the court could have done. So this was such a bizarre posture. The case was such a bizarre posture, don't read defendants. That one will have a preliminary injunction hearing, I think October 1st. And that could go to the Fifth Circuit by November and could actually get to the court's docket by the end of this year. That's my
Agree. I think you can read a lot into that.
okay.
This lawyer, John Mitchell, constructed, and therefore it was hard to figure out who to sue. But let me just give you a counterfactual. If the Commonwealth of Massachusetts had passed a statute